So say two people went and they got in an accident and passed away and they just had a will. How would a house be distributed? Essentially what would happen is after you passed away, your personal representative would be appointed, and at that point, that person comes in and the house actually goes into the name of the estate. So your personal representative goes and signs all of the closing documents as the personal representative of your estate. It's certain documentation that needs to be filed and needs to be completed. Any title company would know how to do it. Most real estate agents know how to take care of it. Essentially, and what they would do is after they would sell the piece of property, then that asset would go into the estate account. And at that point, those assets would then be distributed 3 ways equally, or however many kids you have, or whomever you'd want it to go to equally. So that's how you avoid a transfer on death deed, is you would just do it based on your will. And your will doesn't have to specifically state, my house in Fridley, Minnesota. You can say any assets that I have. I want all of my assets to be distributed the same way, equally between all of my children or to my cousin, however you would want it. He said, what if one child would want to purchase the house? Typically what I would do, if you know for certain, like a lot of people who have cabins, if you have one child you know is going to want this cabin, you can put a special provision in the will saying that this child has the first priority to purchase the home. If they decide to purchase the home, it comes out of their share that they'd receive from my estate. If there's not enough money in my estate, they can come forward with the extra cash to pay it off. And that's a way that you can do it. Otherwise, if they don't, if it's just a plain old simple will and child A comes in and says, hey, I want to buy this house, essentially that if all the children agree, that child can purchase the home and then they can take it out of their share. So, and again, if they're short, they need to pay the other children that value. And again, they can come to any sort of other agreement that they want to come to, but that's how it would be done, logistically speaking. Determining the price of the house, typically what we would say is that you'd have either a real estate agent come out and say this is the value of the house, or you'd actually get an appraisal done. Sometimes we've had it where we know that there's going to be issues, so we'd say 3 appraisers have to come in and appraise the house, and then they pick the average of the 3 values of the house to determine the value. So, and again, as a personal representative of your estate or as a trustee of your trust, you have a fiduciary responsibility to the decedent's estate. So, and a fiduciary responsibility to the other beneficiaries. So even if I was the trustee, I would have to do everything that's in the best interest for my siblings as well. So you have to do it that way. Does everybody do it that way? Not at all. Yes, he said, can you come in and contest, basically, essentially, when do you come in and when can you contest somebody being appointed as personal representative and when is it too late? When you do an informal proceeding, you have to give notice to anybody who's an interested party. So that means anybody who's an heir, so anybody who could take if there was no will, and anybody who's named underneath the will needs to be notified that the person died and this person's going to be appointed as personal representative. Then it's also published in a newspaper, and during this time period, people have to come in and file an objection within a certain period of time, and if they don't file the objection within that time period, the person is appointed as personal representative. At that point, you can't come forward and say, well, this person can't be a personal representative. However, you could come back and say, this person is not doing their job as a personal representative and they need to be removed, or this person's breaching a fiduciary duty. Yeah, and unfortunately, we've seen that time and time again where people just, they either file the documents that they want to be filed because they favor them a little bit more, or, all of a sudden the tangible personal property list goes missing. That happens quite often. So, it's unfortunate, but obviously keeping things with your attorney is probably the best way that you can take care of it. And I should go on a note right now because a lot of people do this. I would say the majority of my clients, they get a will done, and then the attorney gives them their will, and they've got this original will, and they go stick it in their safe in their house. They said, this is the safest place, it's in my safe. What happens when you die? If nobody knows how to get into the safe, and nobody knows that a will's in there, we have had this issue that it's just a horrible thing to have to deal with, is all of a sudden, how the heck do you get into the safe? How do you know what's in the safe? Typically what we do is when any of my clients sign an estate plan, we actually keep it at our firm. The original will. We obviously give you copies of whatever you want, and we typically say, if you're going to fill out a tangible personal property list, send it back to us. And then what we do is we give you a bunch of cards, and you go tell your family, your loved ones, whoever your personal representative, I have done a will. My will is at Dorsey and Whitney or whomever law firm it is at. When I die, you need to call them, and you can get my original will. And we store it for free. and the majority of law firms store it for free. It's in a fireproof, waterproof vault that we have. And then once you pass away and somebody notifies us that you pass away, we give them the original will along with any tangible personal property lists. And that's probably the best way to do it, because otherwise, say a lot of people will say, oh, it's in my top drawer in the room. Well, son doesn't like some of the stuff that's in it. You can get rid of it and he can get everything the way he wants it to. And again, we've seen that too. So it's important that you know where your original will goes. And a lot of people will say, well, how about a safety deposit box at a bank? Well, you can do that, but again, who has access to that safety deposit box? Will they know that the safety deposit box exists upon your death? And then in addition to that, sometimes banks don't allow you in until you have somebody appointed as a personal representative. Well, how can you appoint a personal representative without the will that's in the box? So it's kind of a double-edged sword. And then you have to go formal, and it's a nightmare. So again, for simplicity reasons, typically that's why we'd keep an original will. And then if anybody would want to go to a different attorney or they want a new will, then we just have them destroy the original copy. So you can probate a copy of your will, but again, it has to go through formal probate, which you'd have to go in front of a judge, and then it would be a more of a complicated process. So you want your original will, because that's what's going to have to be probated, because what you do is somebody passes away, you actually file the original will with the county, and they take it there and they keep it there for the lifespan of however long they keep court documents. A lot of our business comes from people who haven't properly planned for disability as well. Meaning that, say my mom became incapacitated in terms of, say she got dementia and she didn't have anything planned at all. Like, who would take care of her assets? Who would, decide where she lives? Who would help make those decisions? If you don't have proper documentation, like a power of attorney or a healthcare directive, the court is basically telling you then you have to apply to the court to decide. Anybody who is anybody should have a financial power of attorney, and this would complete an entire estate plan, I would say, with a healthcare directive, power of attorney, and a will or a trust. But a power of attorney is a financial document that can allow a person to come in and move your assets around while you are still living. So if my mom became incapacitated, had dementia, I could come in and actually pay her bills for her. I could come in and transfer assets around for her and for her benefit. If there is nobody appointed from a financial power of attorney, essentially another conservatorship has to be open, and you'd have to go to the court, and you have to get the court approve you as a conservator, and the court would dictate what you do. And again, then you'd be under court direction. It's a very costly and timely thing to do, and you don't want the court having to tell you what to do. So a financial power of attorney, it is a very simple document that's not costly whatsoever to have it prepared. You can appoint somebody as your attorney in fact is what they're called, who can come in and do that. It's called a statutory short form power of attorney. The state of Minnesota releases it. It's an online version you can actually get, and essentially you can say, here are all the powers that you have, or you can limit the powers, saying this person can sell my house upon the signing of this, and you can limit it by date and all that kind of stuff. But typically what we would recommend is that you would sign it, give full powers, and then keep it hidden until it's time for it to be used. And essentially you would just tell your family, if I became incapacitated, please contact Dorsey and Whitney for a copy of my power of attorney. A healthcare directive, on the other hand, only deals with healthcare situations. So if it ever got into the situation where I went into a coma and I wasn't able to speak for myself, a healthcare directive would dictate a lot of things that I would want, saying, if I were in a permanent vegetative state with no chance of recovery, at that point, this person can make the decision for me whether they would pull the plug or not, essentially is what it would be. And also in terms of if I want to be an organ donor, a tissue donor, if I want to be cremated or buried. I've had people do healthcare directives that are so detailed it talks about what songs they want played at their funeral, and that is perfectly normal for people to do that. But again, healthcare directive is an important aspect for making health decisions. I would say a lot of people, if they have children, typically a spouse would be first, and then their children can make the decisions for them. If you don't have children to make those decisions, somebody who knows your wishes. Ultimately, it's just important that you let everybody know what you want. If you would want to be cremated, if you'd want to be buried, that's important to let them know, and having it in their healthcare directive kind of solidifies it, because we've also seen issues where one kid says, it's time for mom to die, let's just you remove her from life support and another kid says no, well, whose decision makes that? And then they can go to court over how long is mom going to live, or how long is mom, not going to live. Power of attorney is the Minnesota statutory short form. Power of attorney is the full name. You can get it online. You have to be careful on how you fill it out, because you just want to make sure that you're not clicking boxes that you shouldn't click. And you just basically you sign it in front of a notary, and then it's a valid document. A healthcare directives vary from firm to firm, to place. Sometimes hospitals or clinics will give them to you as well, so you can go there and they can give you a healthcare directive, so you don't have to get one from an attorney, and that can do the job as well. But typically I would say a full estate plan, we do healthcare directives and powers of attorney. I typically charge nothing for them because I have my secretary draft them and then I review them, and then it's just with the full package of it. But you should have powers of attorney and healthcare directives though, for sure. Yep, and then some people will say, oh, I already have a power of attorney, I only need a healthcare directive and a will, and a lot of times that's great. The power of attorney form changes in the state of Minnesota every couple of years, so it's always important to get the most updated version, because there is question where people will say, is this latest version valid? Because I literally had somebody come with a power of attorney the other day that was from the 80s, and they wanted to use it. And I said, well, we should probably do another power of attorney if this person's still in capacity to sign. So it also is extremely important on who you select on the power of attorney, because this person will have basically, if you fill it out like we suggest, that person will have full access to your finances immediately, even if you're not capacitated, or even if you are capacitated. They can come in and basically move all of your assets around and steal of your money blind. There was a case in Minneapolis in Hennepin County where there was a mom who had 3 children, and she had dementia. Son came in, there was 2 other siblings. Son came in and stole over $29 million from mom while she was in a nursing home. And there was like a couple $100,000 left by the time that authorities and attorneys got involved, and now it's collecting those assets. So you have the ability to come in and take the assets. So that's, again, you have a fiduciary responsibility, but what is this person going to do? They've just stole all of these assets and they've used it all. So now the other kids are robbed blind. Mom's almost living in poverty, even though she had worked her whole life for a fortune. So it's extremely important that you pick the right people for these positions, because I don't say it lightly. I say it because we've learned from experience that people can misuse, these documents. He said if you already have some documents, do you just amend them, or do you have to completely replace them in their entirety? Essentially, it depends on what your documents are and what you want done to your documents. Sometimes an easy codicil to a will, a codicil is essentially an amendment that you would take care of everything. So say I want my distributions to be different. So say I was giving 1/3 to each child. Now I want 1/2 to go to this child and 1/4 to go to these 2 children. That'd be a simple codicil that you would do. If it's going to be more extensive, sometimes it's just as cheap to get your whole will redone. Because there's times where I've had somebody send me a document that is so old that if I were going to start doing codicils, I'd have to redo the whole thing in its entirety anyways, so it's cheaper for me just to redo the entire thing. And logistically speaking, I'm very forthcoming when it comes to it. I have advised people that you don't need any changes to your estate plan, and then I send them on their way, and they never pay me a thing, and that's perfectly fine with me. I've had people come in and say, you don't need an estate plan, because they had proper beneficiary designations and they had 1 child. So it was easy for them. It's also important to, once you're doing your financial planning at the end too, is to look at your beneficiary designations on all of your accounts. Some people, recently I did an estate plan for a couple, and they had their grandchildren listed as the beneficiaries of their retirement account. Well, their grandchildren are minors, so you can't give them the money outright. So then a conservatorship would have had to been commenced if I didn't catch it. So we set up a trust for their grandchildren, and we're able to move the beneficiary designations around, so we never had those issues. So that's an important thing that you guys need to think about too, is beneficiary designations. And when do you need a trust and a will? If you have a trust-based plan, if I would advise you, or you'd want a trust-based plan, you would always have a will as well. The will is like when we do a trust and a will-based plan, the will is like a 3-page document that essentially just sends it all over to your trust agreement. And you always do that because, again, there are assets that are missed. What if somebody is single and has no assets, and has more debts than whatever assets that they have. This does happen quite often. It's actually called an insolvent estate. Typically, if somebody dies with a ton of debt and no assets, you can just say, screw you creditors, because that's essentially what happens, is that those creditors are just left high and dry. So I have some people will have, there's certain assets that need to be distributed, or some people want to have an estate anyways. So say mom passes away, she had a ton of debt, but she also had this house, and basically all the debt's going to eat up the value that comes out of the house anyways. But you can actually charge a fee for administering the estate. And in terms of creditors, there's a creditor priority list that Minnesota statutes calls. Attorneys get paid first because they write the laws, and don't ask me, I'm not the one who did it. Attorneys get paid first, and then personal representatives or administrators get paid next. So I did an estate where the debt far exceeded any value that they had, but again, there was some assets that needed to be taken care of. So essentially they charged a fee to administer the estate and to pay off all the creditors. Once you get to there's a certain level of creditors, basically after attorneys are paid, personal representatives are paid, the IRS is paid, Minnesota State, the revenue is paid. At that point, it comes everybody gets into a group, and if there's enough money to get to this group of creditors, like credit card individuals, Comcast again, basically, if they have some assets to go there, it's distributed based on a pro rata share. So if this person's owed $10,000 and this person's owed $5,000, they get whatever percentage based on what's left. Nope, the credit card companies cannot come and sue the survivors. You can have the situation if money is wrongfully distributed to the family, like we know that there's this ton of debt and they're distributing the assets anyways, there's a potential that they could come back. I will tell you in terms of creditors, they kind of get the short end of the stick in situations too, because if a probate's never opened, there's no way that they can kind of file a claim against your estate. Unless they open up a probate themselves, and the majority of the time it's too much of a hassle if they know it's insolvent. I mean, trust me, creditors latch on when somebody dies, they start calling immediately to get their assets and to collect their assets. But a lot of times if there's no probate opened, there's no way that they can collect the assets. Will they try to intimidate relatives? There are strict laws that they're actually not allowed to do that. So they should not be contacting anybody. And relatively, I would say the creditors, like for some of the estates that I've had, they start calling the attorneys because the personal representative wants them to start calling us. They call in and just check in periodically and see how things are going. I mean, they know that they're not going to collect on the majority of the assets. When people have passed away and you say it's an insolvent estate, they're likely to not collect any assets. But again, I mean, I'm sure it's a write-off for taxes for them too. And a lot of times, a lot of creditors will actually sell their debt to a third party. There's companies in the state of Minnesota that they do this. They've created a company where they actually will purchase debt from credit card companies at a discounted rate, and then those people were the ones that will come after you. And that happens very quickly, very quickly. Typically, I would say a credit card company will get rid of the debt within a month or two after your death, if they know it's insolvent and they know they're not going to collect. And then these people will come in and try to collect the entire amount, and then they'll try to negotiate with you a price down. So, and I do recommend, and this is probably good to note, is that if you are administering anybody's estate and you're trying to talk down debt, you can actually call them and say that you want the debt reduced if you'd pay it immediately. And typically they can reduce it anywhere from 10 to 30% for you. So I've talked down, one time this person had $30,000 in credit card debt, and I was able to negotiate it down, and all the beneficiaries got a lot more money because we talked down the debt and just paid it immediately. She asked if a reverse mortgage is a good idea or a bad idea. I have had one experience with a reverse mortgage, and it was not good at all. Somebody passed away with a reverse mortgage. It became due in full, and they wouldn't give the person an opportunity to collect the assets to even pay the reverse mortgage before they tried to take the house, and it was a nightmare. But I've heard other people who have thoroughly enjoyed their reverse mortgages, but I would typically not recommend it in a stance of upon death, because that is when it's typically they want their money and they want it now. He asked kind of what percentage of estates are insolvent in the state of Minnesota. It's more common than you would think. That would actually, estates that have to be administered even though they're insolvent. At my last firm, we dealt with insolvent estates quite more frequently than we do at my current place of employment. I would probably say maybe 10% of the estates that I worked on were insolvent when I was at my last firm. So, I mean, it really varies. Some attorneys will basically only delve into the insolvent estates because, I mean, it's kind of fun to track down all the creditors and try to figure out how are we going to pay, how are we going to figure out this estate. So some attorneys will stick with insolvent estates and enjoy it thoroughly. If I did a will-based plan with a will, a healthcare directive, and a power of attorney, I would typically say it would run anywhere from $1,000 to $1,500 for a couple. A trust-based plan, sometimes it can go out $2,000, just because then I have to draft the extra documents, and then signing is a little bit more complex. Otherwise, I would say most attorneys would charge around $1,000 or more for a estate plan. Just a will. Again, it depends. I've done a will, like a will for a couple. Recently, I did one for $750. I was able to complete a will for a couple based on, just on that. So, and it really varies because a lot of times some people are long-winded and want to have these long conversations where we sit and talk for a couple of hours, which is great. I mean, I enjoy meeting my clients and knowing more about them too. But, I've also had people who want me to walk through every single provision in their will, which is great. I want them to understand their documents. But then I also sit there for 4 hours to have to sit and talk with them about it. She asked if it's a benefit to be prepared. And it certainly is. And typically what we do to help prepare any of our clients is we actually send an estate planning worksheet to you, and it would tell us who all of your assets, your addresses of your children, I mean, kind of basically everything that you could think of, you'd put on this sheet. So I have everything there, so we don't actually need to go through everything. Again, I always want to know beneficiary designations on accounts and things like that so I can kind of help direct those assets. But yes, coming prepared is huge. So she's saying, what would happen with my bank accounts, my stocks? Do I need to individually list everything? No, you do not. Nope, because that would just be considered part of your residue. However, I do recommend that you have a list of all of your assets so you can provide that to your children upon death. It's a huge thing that we've seen too is that we draft an entire estate plan and then mom and dad died. Mom and dad never talked about any money that they had to their kids. So their kids come in and say, what did mom and dad have? I don't even know where they banked. So, and it's important that you have a list of, I've got this stock here, I've got this investment fund here. That's really important to have. And it's also, I should note too at this, you should also have a list of all of your passwords for everything as well. And this includes, I'm not just limiting to, your bank account passwords, but like for Facebook and any social media websites, it's really important that you provide the information to your family as well, so they can actually access those accounts and close them down if they want. Otherwise, you're never allowed to get on them. I had a friend who her sister passed away recently and they wanted to close down her Facebook account and Facebook wouldn't allow them. So, and there's been litigation over things like this. And it's important just to have those accounts there. What he's saying is there a document that you can draft to essentially have the personal representative come in and access these accounts? Yes, the letters testamentary, when the person is appointed, would have the ability to come in and to collect those assets and collect those, to access the online bank accounts and everything like that. Typically what we do is we actually give you a separate sheet as well that has all of your passwords and all of your usernames. So, and you actually put that on there, and we give that to the personal representative when somebody passes away.
Those change quite a bit, though. That's the only problem.
And typically we say anytime that you update it, you send it to us, which sounds horrible. And even if you don't send it to your attorney, even providing it to your children or whoever would want to have access to those accounts. Should you be able to access a bank account on like an online banking account, when somebody passes away, you probably shouldn't enter it in their name at that point. But if somebody's incapacitated, you'd have the ability to go and do online banking for them if you have the passwords for it and you are the attorney, in fact. So it's really important to have that information. And I know a lot of people who are older say, well, it doesn't really matter. But I mean, is now that generations are moving up and everything is becoming electronic, having access to this information is huge because you really put somebody at a standstill when we're administering an estate or somebody's incapacitated if you don't have those passwords. What she's asking is if somebody's not doing their job as a personal representative or as a trustee, what do you do? Recently, I had a situation where I had a brother and a sister. Mom died, it was like 8 months ago. Brother did nothing. Brother just sat there, and the house sat there, and sister paid all of mom's bills during this time period. And sister was like, we need to get moving, but he was appointed as the personal representative and she was the successor, so she couldn't act. So what I did, she hired me and I went to them and I said, look, let's, either if you don't do this, I'm going to file a probate and force a probate proceeding. And then I'm going to ask to be appointed as personal representative because you're not doing anything. But in the situation, I was able to contact him and we struck a deal where basically he accepted his position as personal representative and we appointed the sister as a co-personal representative so the both of them were able to act. Was it pretty? It was not pretty during the administration, but because again, they were at each other's throats. She's saying that some tangible personal property wasn't distributed the way it should have been upon death. And unfortunately, I mean, it's kind of one of those things is you're going to have to go to court for it. And then you've got the cost of litigation. So you're saying, well, the cost of your bedroom furniture is not what it's going to cost an attorney to do it. It's going to cost way more than that. So, and unfortunately, that's the cost basis analysis. Is it fair for this person to get away with that? Absolutely not. And should they? Absolutely not. She's saying, can I just do something online for like a power of attorney or healthcare directive?
Have the document, get it notarized, and then that's good to go.
Yes, as long as you fill it out correctly, it should be good to go. But I would never, just to note, I would never scratch anything out and do it. I would actually re-execute an entire document because we've seen it in wills too where somebody comes through and crosses out a name. Unfortunately, if that's the original will, then you've got issues with that as well, and the court would make you go formal because if somebody's name is scratched out. In your will, if you're going to be crossing somebody out, if you want somebody out, you would just do a simple codicil to remove that person. Just crossing out would cause confusion in the court and they'd make you go formal. And again, it would be expensive. Yes, he said, do you need to name somebody by name in the document? Yes, you do. Typically, you would say, I nominate Kylie Henry is my personal representative. If Kylie's unable to, I want Hank, whatever. And that's how you would do it is for the successor personal representative. Sometimes you don't need to do a name if you're going to do a corporate trustee, but again, that would just say, I'm having U.S. Bank, and then somebody at U.S. Bank upon your death would then come in and take charge. And they would be assigned one trust officer or personal, a state officer would take over it. There are some things that I will recommend that you would never put a trust or an estate as a beneficiary designation, specifically on IRAs. There are certain tax consequences. So say if it's extremely complicated how it goes and it changes constantly. But say you have an IRA and you make it payable to your estate or to your trust, typically then the tax that's due on it is payable immediately before distribution or liquidation of the account. If you actually give it to, say I'm giving it equally to my 3 children, my IRA, that basically what they do is they'd make 4 or 3 separate IRAs for each of the kids, and then it basically rolls over in as an inherited IRA, and the tax hit doesn't happen immediately. It happens over a time period. So we've seen that where people will say, oh, I'm just going to list my estate. Well, then all of a sudden there's a huge tax on it where it can be avoided. So, yes, yep, and there are situations I've had where kids are minors, and how would you can't give it to them outright, but you can actually create an inherited IRA and put it in the name of a trust as well for a child. So it's basically administered pursuant to the trust that's in your document, but you just can't blatantly just say my estate, because that's when a tax consequence would hit. The financial power of attorney and just a power of attorney that I'm referring to, it's the same thing. The full term is a Minnesota statutory short form power of attorney. And I think there's a 2016 version is the most recent version that's been released. That is the one that I'm referring to for your power of attorney. Sometimes people will say a power of attorney for healthcare. We call it just a healthcare directive. Other people will say, I don't even know some of the other terms. I've heard them numerous times, but it's totally separate. Those are 2 separate documents. A healthcare directive cannot touch anything with finances, and finances can't touch anything with a healthcare directive. So, yes, any other questions at all? And if you want to, I'll stick around for a while too, so if you have any questions, feel free to let me know, or you can give me a call and we can talk about it as well.